Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh, yay, oh, yay, oh, yay. All persons having a manner form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and its honorable court.
I don't see any attorneys.
I don't either.
Mike? Oh, there they come.
Oh. Okay.
All right, I think we're ready to begin. We'll start today with Bryant versus Stephen. And let me just check with counsel. Mr. Ross, are you there? Can you hear me?
Yes, Your Honor, here.
All right, and Mr. Van, is it?
Yes, Your Honor, I'm here.
Oh, it's Lindsay Van, right, okay. And who else do we have on?
Thank you.
Excuse me, sir. Mr. Raphael, you're in the second case, sir. Would you please turn up your video and mute your audio?
Yes, I will. Thank you.
Sorry about that, sir.
Okay, I think we're all ready to go, and we'll start with Mr. Ross.
Thank you, Your Honor. May it please the court. Simple rules are often the most difficult to follow. A simple but fundamental rule of habeas review under 2254D is that relief is unwarranted unless the state court adjudication involved an unreasonable application of Supreme Court precedent or is based on an unreasonable determination of the facts. Time and time again, we're reminded that it's not enough for a state court to be merely wrong. An incorrect adjudication is fundamentally different from an unreasonable one. It's all too tempting for us to sit in the shoes of the state court judge and assess whether or not that judge got it right or wrong. But that's not the issue under 2254D. Federal habeas review is designed to correct extreme malfunctions in state criminal justice systems, not a substitute for ordinary error correction through appeal. As applied to this case, the district court erred and should be reversed because the scope of its review exceeded that which is permissible under 2254D. The district court held in ground one, dealing with Mr. Bryant's right to a competent jury under the Sixth Amendment, the court held that the state adjudication was an unreasonable application of Supreme Court precedent and an unreasonable determination of the facts. And the district court was wrong.
Well, Mr. Ross, the PCR court found that, quote, juror 342 testified she heard all testimony during the guilty phase and that there was not, quote, a sufficient showing that juror 342 missed material testimony at trial or that her hearing difficulty was of such degree as to indicate that she missed material. But in fact, the juror herself testified that she had trouble hearing and missed some of the material. So how is that not an unreasonable finding by the PCR court?
Well, step one, Your Honor, is to identify what the standard is. And the PCR court actually identified this issue at the hearing and asked the court or asked the parties, is there any law that defines what a competent juror is? And quite frankly, there is no law or standard from the Supreme Court identifying what is a competent juror and what is not a competent juror. What disabilities?
Well, are you saying that if someone can't hear the testimony fully, they are still competent to sit as a juror? Without accommodation? I mean, maybe there's a reasonable accommodation, but as I understand it, this juror refused to wear a hearing aid or was quite defensive about her hearing, according to the testimony of her husband. And perhaps that's the reason she was sometimes reluctant to admit that she couldn't hear, although she did ultimately admit she could not hear at times.
Your Honor, one of the open questions from the Supreme Court precedent as it stands now is, what is the standard we use to assess whether or not somebody can hear or whether or not they can't hear? Do we look at it from a qualitative perspective, a quantitative perspective? Do we look at the amount of testimony that the juror heard? Or do we look at whether or not any testimony missed was material?
Based on what? Based on what she says?
She says she missed some testimony. She repeatedly tells the court she can hear over and over again. She says she.
But how does she know what she can and cannot hear if she can't hear? She can't tell you what she didn't hear because she didn't hear it. But looking at the objective record, the trial judge repeatedly had concerns with the jurors' hearing. The solicitor, the state even had concerns with the jurors' hearing and wanted her removed. And then the husband also testified, of course, that she had a problem hearing. So I don't know how we're supposed to take her word for it that she could hear everything. She doesn't know what she heard. Or
Your Honor, we're not just
go ahead.
We're not taking her word for the amount of testimony she heard or whether or not she missed anything. At the end of the day, there was consensus by all the members in that courtroom. Trial judge believed she was qualified. State believed she was qualified. 2 defense attorneys believed she was qualified. And most
now, the defense attorney testified at the PCR hearing that that juror never should have been on the jury, right?
He testified in hindsight, and that's another error that the district court made, is in reviewing trial counsel's performance, we don't judge that in hindsight. And that trial counsel's testimony is riddled with an assessment in hindsight. He says, when I read the transcript, I didn't realize how deaf she was. So what matters is at the time, whether or not that trial counsel believed this particular person was qualified. And the juror's statement that maybe I missed some, she's also saying she heard everything as well. The burden is on Mr. Bryant to show, number one, what she missed. We don't know if she missed.
How is he supposed to show what she missed when she doesn't know what she missed? It's like that. I haven't been on an airplane in a while, but there's that thing on the seat in front of you that says, if you can't read English, blah, 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 and it's written in English. So if I can't read English, how's that sign any good to me? And that sort of reminds me of this. If she can't hear, she can't tell you what she can't hear. So I don't know how Mr. Bryant could ever make that showing.
Well,
how could he?
This particular juror had a subpoena. She appeared at the PCR court, apparently going to testify. Mr. Bryant could have put her on the stand and asked, what do you recall in mitigation? What do you recall in aggravation? Give us your recollection of the facts of this case, and then compare that to what facts actually are revealed in the transcript. So a showing can be made. Mr. Bryant simply didn't do it. And getting back to the standard.
I'm sorry, and can I just clarify we're only talking about the sentencing phase, right? Not the guilt phase. That in the district court find that was any error was harmless in the guilt phase, and
yes.
There's no appeal on that, right?
Yes, Your Honor. The district court found there was no appeal on the guilt phase because the evidence of guilt was overwhelming. Was the district court?
Right. Okay. Go ahead. I'm sorry.
Let me ask that. I want to ask the question. The PCR court held essentially that the juror did not have a hearing difficulty of such degree as to indicate she missed material. What does he mean by that? What does he mean by the material? Does he mean by everything, or is the material being used as an adjective? I couldn't quite follow that.
As I recall, the district court's order was material testimony, and that raises the issue of going back to what is the standard that the Supreme Court has given us. There really is not a standard in place. The best precedent we have on this issue comes from Jordan versus Massachusetts, Tanner versus the United States. They both recognize that you have a right to a physically and mentally competent jury. But again, the Supreme Court has never defined exactly how we figure out whether this particular juror is qualified.
So if I understand you correctly, you're not saying that she did not have any difficulty in hearing. That's not your position, is it?
Your Honor, it's clear from the record 2 things. Number one, she had an impairment. And number 2, she's not deaf. Now,
So from that perspective, my point is, do we need to come to a conclusion like that to hold for you that she didn't have any difficulty?
I think simply having a hearing impairment standing alone is not going to disqualify someone from service. That's why the devil is always in the details. You've got to figure out the extent of the hearing impairment, and you've got to put some type of metric on how you assess that juror's ability to consume and evaluate the testimony.
So that's why I asked about the missed material and got your interpretation of it, at least your understanding that you believe he's referring to material testimony, not that he missed material, meaning everything in the process of it.
As I read the order, it's material testimony.
Can I ask a question? And the courts have over the years had fairly regularly issues about sleeping jurors, where a juror falls asleep in the afternoon or during a period of time. Are you aware of any court that has established some kind of standard, how long you can sleep before you have to be disqualified? In other words, this is a little bit along the same lines as you're talking about what evidence was missed or not. You've agreed that, or you've suggested that the test might be material evidence. I'm wondering whether there is any suggestion as to how much time or what percentage or what degree a juror can miss before that juror becomes incompetent, because I think most of the cases have overcome a certain level of sleeping during a trial without disqualification. And I'm just wondering, is there some standard or something we should be looking at in terms of time period or preoccupation with sleep or with not hearing?
As I understand the case law, Your Honor, the various courts have looked at the amount and the materiality used. I believe different courts have looked at, again, the amount of testimony missed. Other courts have looked at whether or not it's material testimony. So that reinforces the debatability of the rule that would be applied here, that reasonable courts could look at different metrics in assessing whether or not a juror is qualified. Are they missing 60%, 70%? Are they missing something that's critical to the issues at hand, or are they missing something that's cumulative? So as I understand, and there's a host of case law dealing with sleeping jurors, and courts have addressed it in various ways, which would simply reinforce the reasonableness of the PCR court in this case, because there is no firm standard in place. And when you don't have a firm standard, courts have a lot more flexibility in applying the rule. Does that answer Your Honor's question?
Well, it points up the problem. I don't know if it really answers it. It's a difficult call because this record is somewhat speckled. I mean, every time the trial judge asked the woman whether she was hearing, that she would usually say, yes, I heard that, I heard that. On the other hand, I think she gave the juror 3 tests, at least 3, and she passed 2 and failed 1. So I don't know where that leaves us either. It's in the same never land between the 2 posts you were talking about, or in the case of sleeping jurors, between the length of sleep and amount of material missed.
One thing is clear from the facts in this case, Your Honor, is that, again, we know she's not deaf. And we know that based on, during her various responses to the court, she's not simply answering in yes or no questions. Had she answered simply in yes or no, then we may be able to infer that she was just flipping a coin as to what was coming out of the judge's mouth. But repeatedly, she's answered several questions in full sentences. She explained the presumption of innocence to the judge. She explained that she needed to read lips to the judge. And at one point, she's asked where her church is, and she gives a description of where to get to her church. So she's not answering in just yes or no questions. We also know that the lawyers are making efforts to accommodate this issue. At different points in the transcript, you can see where the trial attorneys are physically moving in the courtroom. That's at record 188 to 190 and 194. One of the trial attorneys physically picks up the podium and moves it so that he can be within eye range so that juror can actually see his lips and read his lips. You mentioned one specific instance where at the culminating moment where the trial judge is assessing this juror's qualifications, the issue about the blue dress, navy blue dress. From experience, when a judge looks you in the eyes and asks you a question, sometimes you can see the judge's lips moving and you know the judge is talking to you, but you're not listening to what's coming out of her mouth. You're thinking of something else. So that is not the smoking gun piece of evidence.
Well, I didn't suggest it was because she had also been asked 2 other times. One, there was some evidence that she was nudged, but it looked like she clearly passed 1 or 2. She was hearing something. There's no question about it. But with the blue dress, she did say, "I didn't hear that." And so the question is whether she wasn't paying attention or she didn't hear it because of an impairment. And I suppose it's probably her impairment, but it is a mixed bag.
It would be up to supposition.
Doesn't your example of the lawyer having to turn the podium around and face directly toward her underscore the argument that she could have been missing, as she, I think, indicated, parts of the testimony? If somebody did not have the podium turned around directly at her, that sort of cuts both ways for you.
That particular incident occurred at the beginning of the guilt or innocence phase. So it appears that they had begun making that accommodation before we're getting into sentencing, which is what the trial court or the district court's order addresses. And I say that my time is...
Yeah, okay, we'll hear you on rebuttal. All right, Ms. Van? Is it Van or Vaughn?
It's Van, Your Honor.
Okay, thank you.
Thank you. May it please the court. As you've understood, this is a highly unusual case where everyone involved noticed that there was a hearing problem with this juror. The district court properly found that the service of this juror, who admitted that she missed portions of the trial testimony, was a violation of Mr. Bryan's right to a fair trial.
Ms. Van, you're breaking up. Just a minute. I believe you're... I'm having trouble because you're breaking up. I don't know if there's something we can do.
It appears that the internet, it says it is fine. Can you hear me now?
I can hear you, but it's jerky movement and jerky sound.
That's going to be with her internet connection, sir. So, Ms. Van, are you home?
I'm at the office.
You're at the office? Okay. I don't know if you have are you on wireless or if you have a wired connection, but yeah, you're breaking up a little bit.
I'm on a 5G wireless.
Oh, so you're not connected to the office network. Okay, so yeah, you're connected to your phone. That's probably your problem.
Well, it's wireless Wi-Fi internet at the office.
Oh, okay. I'm sorry to interrupt, Judge Niemeyer. Go ahead and try again, Ms. Van.
Sure. As your honors have recognized, this is a highly unusual case where everyone involved recognized that the juror was having hearing problems, and she repeatedly
but Ms. Van, everyone involved did recognize that, but what about the fact that everyone involved ultimately concluded that, including the solicitor, the defense attorney, the judge, concluded that she should remain on the jury? Given the deferential standard here, how does that not really hurt your argument?
Well, I think what's important here is that Mr. Bryant had a right to be tried by an unimpaired jury where the jurors were able to hear all of the evidence. The findings by the trial court and the solicitors who were recognizing her hearing problems throughout the trial show that she was not hearing all of the testimony. And in fact, she admitted that she did not hear all of the testimony. African-American juror from the jury does not trump the fact that he did not have a jury that was able to reach a verdict on the evidence that was presented up.
So let me ask you a question, and you are still somewhat breaking up, but I think we're catching most of what you're saying. I should say we're catching the material parts of what you're saying.
I apologize, Your Honor.
We are here not on the direct appeal, and you well know, far better than I will ever know, the deferential level of review we give to these matters here. So there's a fundamental question here that we can keep saying she couldn't hear this and you had to move the podium, things like that, but that's not really the issue that we deal with in a habeas capital appeal. It's a very, very high burden that we have here to deal with from your perspectives. Address it specifically there, because I don't want you to spend your time talking about the hearing problem and sounding like it is going somewhere, when at the end of the day, that's the issue we're going to address. And we're going to have to address it knowing just how limited we are as a federal court, and looking back at that state court on this. And it's not my law, it is the law. And you are bound by that on this type of appeal.
Yes, Your Honor. I think that is very important, and that is what we should focus on. So 2254D2 allows this court to grant habeas relief where there has been an unreasonable finding of fact by the state PCR court. And that is exactly what happened here. The state PCR court found that she heard all of the testimony at the guilt phase.
Hold on a minute. Where do you get that principle that a jury has to hear all the evidence? We had a case, the Johnson case. I think a jury missed the whole opening statement, and we said it was all right. So where's this all of the evidence, as opposed to, and I'm just in the context, are you saying that material, a finding that she heard the material testimony is not good enough, she has to hear all? Is that your contention?
No, my contention is that the state PCR court made a finding that she heard all of the testimony, but she admitted that she did not hear all of the testimony.
I thought he used the word material. I thought he used the word material. You heard me speak to Mr. Ross about that, and it was a clarification. What did you mean? But are you reading that to say when you said miss material that they're talking a noun like everything as opposed to material testimony, adjective?
No, Your Honor. In the paragraph before he makes the finding on all material, which we don't know if he means material evidence or just all material, he says that Juror Jones testified she heard all testimony during the guilty phase, and that she was able to compensate for her hearing deficiencies. So that's another point I wanted to make, is that she was not able to compensate for her deficiencies. The accommodations that were supposedly in place did not work. For example, they were trying to make an accommodation for her to be able to read lips, but the trial judge noted that there were times when counsel and the witnesses were not turned toward the jury box, so she could not have read their lips. Additionally, the juror actually admitted that there were times where she didn't know where to look to know who was speaking. So she would be looking back and forth between counsel and the witnesses and would only be able to pick up on the end of the testimony or on the end of the question. So she's missing things throughout the course of the trial.
So I want on that point, I want to, she did testify during the guilt phase that she heard testimony, all the testimony, but beyond that, if the issue here is whether she in fact did miss something, isn't that burden really on you? And you didn't present any type of doctor's testimony, and don't we have to defer to the trial court's apparent conclusion that she could still serve?
Well, the trial court did not make another finding of qualification. The trial court was going through, the judge found that she did not hear the question that was asked about the blue dress. It's not that she didn't know if it was blue or not. She admitted that she did not hear that question.
Well, but my point, at least the question I'm asking, and I'm not being argumentative, is the trial court. You know how many times we've ever said that the court is in the position to evaluate the witness, to see them face to face and determine all of that. Given that, if you want to challenge that, it would seems like to me you might would have brought in a doctor or someone to present some testimony beyond a conclusory statement that, well, it didn't happen.
Well, there was a doctor's statement at PCR with doctor's records about her hearing problems. The husband did come in after, during the PCR hearing and testify about her hearing problems dating back to the 1980s, well before this trial happened.
But what about Mr. Ross indicated that the juror herself was present at the PCR hearing but was not called? What about that?
Your point that you made when Mr. Ross was speaking was that the juror can't know what she wasn't hearing. Also, it's very clear from the testimony at trial and from the husband's testimony that she's not being forthcoming about what she's missing, and she's reluctant to provide that information to the court.
Could you call the jury? Can you call that jury on the South Carolina law to testify?
No, I agree. That also would be asking a juror to testify about deliberations, which would be a violation of evidentiary rules. So under the evidentiary rules, the best testimony was presented. And I think the trial record itself is very important because this is continuing throughout the trial, showing that the accommodations are not working.
Well, I just want you to touch on the last point, and then I'm gonna move and let my colleagues take it from there. But this burden that you have to move forward on this, it would seem to me that given where you are, her statement during the guilt phase and all of the other things here, the trial court's face-to-face analysis of looking at it, that then that burden on you would say, well, let me bring in her audiologist or a doctor or someone and who can tell you that someone with this kind of a disability would not be able to do that. I mean, doesn't it seem reasonable that's that you would at least have to bring in something of that nature to challenge it once that burden is on you?
Well,
and the burden is on you, right? The burden is on the petition. That is correct, right?
Yes, Your Honor. And
yes.
At PCR, the husband testified that when she's standing in the same room and he asks for something, she didn't hear him. But I think
well, I mean, that's good lay testimony. That's what you got anyway. You got counsel and everybody saying that. I'm saying if the burden's on you, then it's a pretty powerful thing to bring in, a doctor who knows about hearing and says, a person with this, I know this from her, she would not be able to hear from that distance or hear that. That, I'm not saying it would compel a result, but it would seem to me that a burden on your part would probably minimally require something like that.
Well, I think the burden in habeas is to show that the state PCR court made unreasonable findings, and that is what we have shown.
Well, it's a little bit more. It's a little bit more than made unreasonable findings. I mean, that sounds pretty benign. That language is a little stronger than that.
Well, that 2254D2 requires that there be, you can grant habeas relief if the state court made unreasonable determinations of fact, and that is what happened here.
And just to clarify, Ms. Vann, it is the unreasonable determination of fact that you're talking about, at least one of them, where the PCR court found that, quote, juror 342 testified that she heard all testimony during the guilty phase,
Yes,
when in
Your
fact
Honor.
the record bears out that she did not?
Yes, Your Honor, it's contrary to the evidence in the record.
Is
Then
there
the court
anything
goes
else?
on-
Is there any other statement or finding that is an unreasonable determination of fact in your view?
Yes, Your Honor. Then the court goes on to say the trial court also took specific measures to ensure the juror could hear the testimony. The trial court attempted to do that, but the accommodations really did not work in this case. The trial court found that when the judge was speaking directly to the jury, raising her voice and focusing, the juror knew to look at the judge to read lips. She still missed questions. And the trial judge then said, well, also, I know there have been people who have been speaking more quietly than I have. I know that there have been times when people have not been looking directly at the jury box. And so there are findings from the trial court in the record that are contrary to what the PCR court found. The real problem here is not that people didn't notice that she was having hearing problems. The trial judge noticed she was having hearing problems. The solicitor noticed she was not hearing all of the testimony, and in fact called her apparently deaf and said it's clear that she's missing some of the testimony. The problem is that they didn't do the right thing. Under the Supreme Court law, a jury has to be competent and has to be able to render a verdict on the evidence that is presented to it. And so with the juror who was not able to hear all of the evidence that was presented, the verdict cannot possibly be on that evidence that was presented in the trial court. And so this is a violation of Mr. Bryan's right to a fair trial. This is a structural error because we cannot tell exactly how much he missed. This juror case, where this juror really should not have been sitting. It's more like Mr. Bryan only had 11 jurors, and so this case should be remanded for a new sentencing hearing. There are additional unreasonable determinations of fact on the ineffective assistance of counsel claim. The state PCR court found that the trial counsel only wanted to keep her because he did not like the alternate and because he did not approve of the way that the jury selection was done via paper strike. But the record is clearly contrary to those findings as well. Related to the alternate, the trial counsel said that he understood if he had wanted removal of the juror, the judge would have granted a mistrial. And so the alternate really didn't come into it. And that's what he testified to at PCR. So this is clearly contrary to what the strategy for not removing the juror. As far as jury selection, as the district court properly found, it was an invalid inference that he didn't like the jury selection process, and so he didn't want to remove this juror because the only way to get a new jury selection process would be through a mistrial, which he believed would be granted. The state attempts to rely on Mr. Bryan's acquiescence to keeping the juror on this trial, but that cannot be relied on because that was not a finding that the state PCR court made, so that does not work under Wilson versus Sellers, which requires that this court review what the state PCR court knew and did. And also the client is not the determining factor of what is adequate, effective representation and who should be on the jury. That was a decision that trial counsel should have made, and they made the wrong decision. If there are no other questions, I will thank you for your time and ask that you affirm the district court's ruling.
Thank you.
Thank you.
All right, we'll hear from Mr. Ross.
When looking at ground 2, the ineffective assistance of counsel claim, it's important to note we're dealing with double deference here. Deference under 2254B, deference under Strickland. And in this particular case, it's clear that trial counsel acted strategically. He knew that he didn't want to request, he knew he wanted this juror on the jury. And had he sought her removal, he would have likely been placed with an alternate that he didn't like. So if he had pressed the issue, if he had actually asked to have that juror.
Wouldn't it have been a mistrial rather than a replacement?
Certainly not entirely clear how the trial court would have ruled. The solicitor, when he made his objection, he asked to replace the juror. He notes that we've got two capable alternates here. Why not just use one of them? So it's completely speculative to assume that the trial court would have gone the mistrial route as opposed to replacing the juror with an alternate. And if you're sitting in trial counsel's shoes at that time, you definitely can't take it to the bank that the judge is going to give you a mistrial as opposed to putting an alternate on the jury. And you certainly can't take it to the bank that any issue like that would be overturned on appeal. So it's very likely that that trial attorney who's making that decision in the heat of the moment is going to make the call that I want to stick with this juror who I think is better for my case, as opposed to flip a coin and get somebody I don't like, and that may be affirmed.
Well, the PCR court didn't directly address that issue of whether the counsel should have asked for a mistrial. How should we deal with that?
The PCR court specifically said he acted reasonably based on his assessment of the alternate juror. So implicit in that finding is PCR, during the PCR hearing, trial counsel's testimony as to why he wanted that juror there. So when the PCR court made the finding that it was based on his assessment of that alternate juror, that's in relation to the juror that was sitting, Miss Jones, the one with the alleged hearing impairment, and in relation to what would happen next. So in addressing the alternate juror, and the PCR court was addressing those other issues implicitly. It's implicitly finding that it was reasonable.
I find it difficult to think that a mistrial would be a possibility unless the evidence corrupted the jury or there was something that got the jury on the wrong track. If a juror gets sick or dies, you just put on an alternate. And if a jury can't hear, I would assume that's the same thing.
That's correct. And there's some state precedent to that effect. State versus Kelly, which is 502 Southeastern 2nd 99, dealt with an issue of juror misconduct at the sentencing phase after they'd already deliberated on the guilt or innocence phase. And that
well, misconduct could also lead to a mistrial. I mean, a jury could be infected. My point is, if everybody's listening, but one person didn't hear anything, then it's the alternates were listening, and you could replace the juror with another juror without affecting the evidence for guilt or innocence. In other words, a mistrial wouldn't seem to be required in that circumstance. But that's, as Judge Wynn said, that wasn't decided by the PCR court.
Well, there certainly is precedent, and Your Honor, I see my time is up. If I may just complete my thought.
Yes.
There is precedent that you can replace an alternate at the sentencing phase. That's the Kelly case I just mentioned. That's why we have alternates in the first place.
Okay. Thank you, Mr. Ross.
Appreciate it, John.
Ms. Van, I just want to note, I understand you were court appointed, and I want to recognize that fact. I don't know how big our audience is, but everybody should know that that's an important service and we depend on it. And I appreciate it very much.
Your Honor, happy to do so.
Yeah. At this point, we customarily come down and greet counsel. In these circumstances, I haven't figured out how that works. So we'll just have to greet you here on the Zoom and thank you for your service to the court. We'll proceed on to the next case.
Thank you very much.
Thank you, Your Honor.
All right, the next case we have is Doe versus Fairfax County. Ms. Brodsky, can you hear me? I can't hear you though.
That seems like a key detail. I can hear you.
Okay, I can hear you now. All right, Mr. Rayfield.
Yes, Judge Niemeyer, I can hear
Okay.
you.
Why don't we proceed, Ms. Brodsky, and then go on.
Thank you, Your Honor, and may it please the court. Alexandra Brodsky for Appellant Jane Doe. Established precedent is clear that when a school receives a report alleging that the plaintiff was sexually harassed, it has actual knowledge. That's exactly what happened here. According to Assistant Principal Hogan's own testimony, Jane and her mother reported that a classmate had touched Jane's breasts
Let me
and
ask you,
genitals.
let me just ask you a question. Was there any evidence that the school board heard about this harassment before it occurred?
No, Your Honor, there was not. And Jane,
And is there any evidence that the harassment continued after this one incident?
no, there is not, Your Honor.
Well, the question, I guess, is was any harassment caused as a result of the school's indifference?
Your Honor, Jane does, there is not evidence.
My question is whether any harassment was caused by the school's indifference.
No, Your Honor. There's currently a circuit split on the question of whether harassment is required post-notice. That is not an argument.
Supreme Court addressed that directly in Davis. They said clearly that the harassment has to be a result of the school's indifference.
Your Honor, the majority position taken by the 10th Circuit, I think most clearly in Farmer, is that when Davis says that a school's deliberate indifference must subject a student to it's either further harassment or vulnerability to further harassment, which the 10th Circuit has and the 11th have understood to mean that if a student is vulnerable to further harassment in a way that affects her education, that's enough. But I'll note that that's not an argument that the school board has pressed here. It shows up in one footnote in the amicus brief.
No, but I understand, but we're looking fundamentally at school board liability, and the liability is based on two components. One is knowledge of a condition in the school, and second, failure to respond such that the harassment is continued. And as you know, Davis, they said, if the funding recipient does not engage in harassment directly, it may not be liable for damages unless its deliberate indifference subjects its students to harassment. That is, the deliberate indifference must, at a minimum, cause students to undergo harassment or make them liable or vulnerable to it. Now, the question is, they had no prior knowledge of this, so they don't have any liability for this harassment that occurred on the bus. And no further harassment continued. I mean, we just conceded that, but that seems to be the record. So when the juror answered the question, did the school board have knowledge of the harassment on March 8th? The answer was no, and it's clearly correct because there's no evidence to support that it knew that that was going to occur or that it was going on at the time it had knowledge of it.
Your Honor, I think it's important here to distinguish between actual knowledge and deliberate indifference.
No, it's not. It doesn't. They're not related. The indifference is after you have knowledge. The liability is based on a school board's, when they're not involved, on the school board's knowing of a condition in the school and not addressing it. And in this case, the condition, they never heard of the condition until after the fact. And the only way an after the fact liability can occur is if there's master servant liability, which Gebser got rid of.
Your Honor, I disagree on that last point. There are many cases where a school is liable for its failure to address past harassment that is reported to it. One illustrative case.
I want to understand the nature of your disagreement. Are you saying, as it seems to me, Davis never held that the harassment must continue? And there's a circuit split on this issue. Is that your position here?
That's correct, Your Honor. And again, this isn't an argument that's been pressed by the school board. There has been no briefing on this from either party. So if the court,
I'm not saying it couldn't be pressed. I'm saying, but it's not pressed from the position that this is something Davis absolutely holds. You certainly can go in that direction because it's not determined which way we will go on it. But that issue is not resolved by or mandated by Davis, and there's a circuit split in terms of whether the harassment must continue.
That's correct, Your Honor. And again,
Well, Davis did address a single event, and Davis said it's unlikely Congress would have thought that such behavior is sufficient to rise to the level in light of the inevitability of student misconduct and the amount of litigation. In other words, the idea, every one of the cases involves an ongoing situation where a student is harassing another student or teachers engaged in some kind of relationship, and the school tolerates it because it knew of it and didn't do anything about it.
Your Honor,
there's no case where after the fact, the school learns about a single incident after the fact and the school's liable.
That's not quite correct, Your Honor. There are such cases, Farmer in the 10th Circuit and Williams in the 11th Circuit. In Williams, a student was subject to a gang rape. The school clearly was not planning to do anything about that, and so she left campus because she felt that she couldn't continue to remain on campus safely. In Farmer, there were 2 students who were raped. The school did nothing to restrain the movement of the people who had assaulted them, and so they didn't attend classes, they didn't feel safe on campus. I'd like, if I may, to talk about the actual knowledge element that's at the core of Jane's appeal.
Let me ask that. Go ahead, Judge. I'm sorry. No, I guess I'm going to defer to the senior judge. Go ahead, Your Honor, please. Yeah, well, that's kind of the way I was looking at this case. There are 4 different little elements before the jury. That is, there's no question of the sexual harassment. It seems the jury found, and the jury found, okay, and it did deprive her of education. It was a notice, and the actual notice and actual knowledge. It didn't reach this in this different deliverance from my perspective, or did it?
It did not, Your Honor, and that's exactly right. Because of the jury's finding on this threshold knowledge question, it never reached the element that actually concerns the school's response, which is deliberate indifference. And Davis, Jennings, these cases are clear that when a school receives an allegation that the plaintiff was harassed, that's enough for knowledge. And here,
but so as to, I'm not in disagreement with Judge Niemeyer that Davis case did say that, but it does appear they said it could be enough. It wasn't before the court. It's really dicta in this so-called one-on-one pure harassment pronouncement in Davis. That was not the direct holding of that case. So that's why the circuits, as you pointed out, are split on it in terms of what that meaning is there.
That's correct, Your Honor. And if this court thinks that this case turns on that issue, I would request that the parties have the opportunity to brief it.
I think it turns on this actual notice and actual knowledge issue here. That both of those terms are kind of interesting. The court uses them interchangeably, and of course, notice is not exactly knowledge. And maybe speak to that in terms of what we have here of a student who goes in, reports it, and whether that was amounted to a situation which the court could find that there was no actual notice and knowledge.
Absolutely, Your Honor. So there has never been a case in which a school has received a report of sexual harassment of the plaintiff, and that was not sufficient for actual knowledge. Here, Jane and her mother, by Hogan's own testimony, reported that a classmate had touched her breasts and genitals.
Well, Ms. Brodsky, just before you go on, you keep referring to it as harassment, but I think you're about to describe the report. Isn't it sexual assault?
I agree, Your Honor, that what happened here is legally sexual assault. I think as Meritor and Davis make clear, sexual assault is a kind of sexual harassment, and the jury found that there was sexual harassment here. I think it's mostly a distinction between civil rights and criminal terminology. Here, Jane's mother even told Hogan that Jane had been, quote, sexually assaulted. Both Jane and her mother described the physical resistance that Jane had to Jack's touching. And as a result, there's simply no evidence in support of the jury's special verdict on actual knowledge. Because the school board cannot dispute these facts, it instead urges this court to adopt 2 novel requirements for actual knowledge. First, the board says that a school does not have actual knowledge until and unless it concludes a report is true. But that position simply cannot be squared with cases like Davis and Jennings, where schools had actual knowledge of reports that they never investigated, and so, of course, did not substantiate. It cannot be squared with cases like Hill and the First Circuit's opinion in Fitzgerald, where schools investigated reports, concluded they weren't true, but still had actual knowledge of them. And in those cases, the school's investigations and conclusions were, of course, part of the deliberate indifference analysis, but didn't affect whether they got the allegation in the first place. Second,
it seems to me that Gebser, in defining the scope of liability, suggested that the actual knowledge was necessary to give the school the opportunity to take corrective measures to prevent the harassment or to end it. And that's what Justice O'Connor talked expressly about and rejected this notion of after discovered evidence. In other words, the jury was answering in the third question, the jury was answering, did the school have knowledge of the incident on March 8th? And they didn't. And it answered correctly because the knowledge has to give it an opportunity to respond and correct the harassment. And in that sense, they didn't. Now, sure, that after the fact, but if you learn about it a year later, does that make a difference?
Your Honor, the injury in question in a Title IX suit is an educational deprivation. It's not the sexual assault itself. So as cases like, again, Jennings, Davis, Morrell—
No, but it has to be responsible. The school has to be responsible for the harassment. That's very clear in both Gebser and in Davis. And the harassment has to be imputable to the school by reason of the school's knowledge. And that's made clear to distinguish from the master-servant agency situation. So you have to start off that the school has to have, its responsibility is based on tolerating a condition, not creating it, tolerating it. And in this case, the harassment was a single discrete event that never repeated itself or was never threatened. So the question is, how could it end that harassment? And it didn't. There was no need to. Now, what you claim is that, well, she continued to suffer afterwards. That's true. But, and the school didn't kick him out. That's true. But he didn't threaten. He didn't stare at her. There was no further harassment. And so the question is, what could the school have done to prevent the harassment? That's the liability under Title IX. The school failed to act when it received knowledge. This idea that notice and knowledge are distinct is hardly meaningful. Notice gives knowledge. It seems to me notice is the incipient event for knowledge. And the statute, of course, uses the word knowledge. So I don't think that argument leads us anywhere in this case to any conclusion.
Your Honor, I think this again goes to the question about whether further harassment is necessary or whether it's enough that after the harassment, the student is deprived of educational opportunities because of an ongoing hostile environment, which needs to sit behind.
Then how do you explain that the indifference must lead to the harassment? In other words, the school must have had knowledge with indifference, must at a minimum cause students to undergo harassment.
Your Honor, the language from Davis is subjects, and it includes vulnerability to harassment, which, as Farmer explained,
still encompasses— if vulnerability to harassment is still that this has to precede the harassment to be responsible.
Your Honor, that's not what Farmer held. If I may, I'd like to talk about
Let's
the
stick
school's—
with Davis. That's the Supreme Court.
That's correct, Your Honor. But again, there's a circuit
split. It went in some detail to explain that. I mean, this isn't. It's logical. You have an institution that knows nothing of what's going on in its school yard, and there's an act of harassment, a single identifiable act of harassment. The only way you can hold the school liable is agency, and Gebsner rejected that. You cannot hold the school liable if it never knew of the fact the harassment occurred, the single event.
Your Honor, I disagree. That again goes to deliberate indifference, and because I see my time
indifference, it goes to the fact that they can't stop it. They couldn't have done anything about it because they didn't know about it.
Your Honor, the school could have done something to make sure that Jane's educational opportunities weren't disrupted. The school board's argument here is also that it didn't have actual knowledge because an appropriate person never labeled the report as one concerning sexual harassment, but no court has—
the efficiency of education has to result from the harassment. And the harassment has to result from, to be imputable to the school board from prior knowledge by the school board. School board can't be responsible for something it never knew about.
Your Honor, the school board, again, is responsible for the educational deprivation, not for the initial harassment. Davis and Gebser are quite clear that the school, that the acts of third parties are not why the school is liable. It's their deliberate indifference that results in the educational injury. I'd just like to say that this court and others have treated a defendant's failure to correctly label a report of sexual harassment as evidence of a deficient response, hardly a defense to knowledge, and for good reason.
Well, it seems to me that the difference here lies in if you accept that there must be this continuing harassment, and if nothing happens to the person after they reports, it's over. You don't have anything to do. If you accept that, then I think you do follow Judge Niemeyer's line of reasoning. But here we're talking about, did it affect her education, and did it affect the quality of it? And so someone, if you follow that logic, then someone could be severely sexually assaulted, and just by reporting it to the school and it never happens again, you would never have a Title IX action. And I think that seems to be where Judge Niemeyer is leading to this. And I'm not sure that's the way the courts have looked at it, at least certain circuits have it. There is something beyond this. You report, here's a young female who's sitting on a bus. She's sexually harassed. That question is beyond question. It has affected her education. She goes and reports it, and the school does nothing and nothing happens if it never happens again. And who knows that the individual who did it may still be a threat. She's got to deal with all of the other instances of being in a school environment where she doesn't feel protected. They've not done one thing. It could happen again. There's the threat of it, and yet they've done nothing. And if that's the case, then perhaps Judge Niemeyer is correct. Then yeah, no Title IX here. But I don't think the cases have followed that way. That this is a very serious thing for which the school has to do more than nothing once they get. The question here, because it seems to me we are assuming, going to that question, there's no remedy, but if we go there as a matter of law, the question is, how do we know? We don't know what they're doing out there. We don't know if he's still out there. This guy's lurking. She's in an environment where she's been violated to the highest degree, worst thing that could happen to her. She reports it to the people she's supposed to, and they do nothing. And then if nothing happens, we just say, okay. That doesn't sound correct to me, but if you will, just brief response.
And just to add on to what Judge Wynn said, as I understand it here, the school did more than nothing. They indicated they didn't think it happened, right?
That's correct.
That's worse than nothing.
That's correct, Your Honor. And I think that both of your questions speak to both the educational opportunity element, where a jury has already found that Jane was deprived of educational opportunities. I mean, she for some time, she didn't even attend her favorite class. She stopped enjoying it. There were parts of the school that she avoided to avoid Jack. And on deliberate indifference, I think that the jury never reached this element, but it very reasonably could conclude that the investigation was a hostile, biased sham from the start. Assistant Principal Hogan was significantly swayed by the fact that Jane wore Jack's hat before the assault, as though that were evidence of consent to vaginal digital penetration. And the school destroyed its evidence. The school discouraged her from taking legal action. So a jury could, and this is to say nothing of its failure to take action during the trip. So I see my time is up.
Okay, thank you. All right, you may proceed, sir.
Thank you, Judge Niemeyer. May it please the court, Stuart Raphael for the school board. This was not a case of a he said, she said, where a principal investigating an incident believes the boy over the girl. This is a case where Jennifer Hogan, as the assistant principal who investigated this, said she believed what Jane was telling her. But what Jane was telling Hogan was not that a sexual assault had happened. And so I take issue with the way it's been.
How does the school board define sexual assault?
I mean, I don't know that there's a definition that they have in their
Would
regulation.
it be
but I think,
non-consensual at least? Can we start with non-consensual?
well, of course. Of course.
Okay, let's talk about what Jane said then. Her note said, I moved my hand away, but he moved my hand back onto his genitals. I was so shocked and scared that I did not know what to say or do. He then started to move his hands towards me, and I tried to block him, but he still put his hands up my shirt and down my pants. What part of that is consensual?
Your Honor, this was a case that this was a full jury trial, and you're pointing to one piece of evidence of
I understand that, but I understand that. Can you address, can you address that though? What part of this, you started by saying that Hogan didn't believe that what Ms. Doe described was sexual assault. So I'm talking about what Ms. Doe described. What part of that is consensual? And then then you can talk about whatever other evidence you want.
Yes, Your Honor. So Hogan asked Jane about that report, and what she heard was entirely consistent with what Jack Smith had said, except for the only detail that was different was Jane said that she tried to block his hand once in the beginning, but then participated for 15 to 20 minutes in mutual sexual activity. And what Jane was really focused on and was fixated on was the fact that Jack had a girlfriend. Jane never said to Ms. Hogan that she never called it an assault. She admitted in her testimony that she didn't think of it as an assault until much later.
Ms. Hogan understood that.
The jury ruled against you on this.
On whether it was an assault or not, but the jury ruled
they called it sexual harassment.
That's correct.
The first question they answered against you, and the second question they answered against you. I don't think we should be arguing that. We should assume there was sexual harassment in this case.
I understood, Your Honor, but it's the third element, actual knowledge, that's the issue here. And because
on that element, the assistant principal Hogan understood the allegation to be one of sexual assault. Hogan admits that.
No, that's not correct.
That's what she says. Hogan says appellant's mother characterized the incident as sexual assault.
No. I think respectfully, by the time she spoke to the mother, she had already interviewed Jane, Jack, and the other two witnesses who hadn't observed.
And Jack also said he understood the school to be investigating a non-consensual touching.
I need to unpack that. By the time they talked to Jack, they had heard Jane's discussion, and Ms. Hogan testified she didn't think that she had an assault reported to her. But when they were talking to Jack,
I frankly don't understand why you are going down this route, because it seems to me the issue here is on actual knowledge and actual notice. You're going to argue here that this lady was not sexually assaulted.
I'm not.
I think you got a difficult road to hoe on that one. And that if that touching was consensual, I wouldn't have gone there, because I don't think you're going to go anywhere with that.
I understood.
But let me address where it seems like we spent a great deal of time on. And I want to be clear. The jury found those two first elements there. I mean, the sexual assault, the educational problem, the whole bit. Then it stopped on the notice and the actual notice and actual knowledge. It didn't reach the indifference. But it seems to me we've gone to a point of saying, well, we can reach it and find as a matter of law there is no remedy here because they didn't show that. Is that what we should be doing here? I mean, should we now get into the whole question of deliberate indifference and deal with whether, well, there's nothing continuing here that went on afterwards. So even if they did get actual knowledge and notice, am I looking at that right? Or am I mixing it too much? I'm confused on that, but help me out.
Sure. So you're correct that the jury didn't reach the fourth question, which was what was their deliberate indifference. We did move for judgment as a matter of law on that. And we have asserted that as an alternative ground for affirmance in our brief. You're exactly right that the principal issue on appeal is whether there was sufficient evidence to support the jury's actual knowledge finding. And I'd like to.
So if you didn't win on, if let's say we said, okay, the jury's wrong on his actual knowledge, actual notice, I mean, and of course, you now want us to take the alternative ground, says, well, they should have found this as a matter of law. But if not, then we send it back, don't we?
That's correct. That's correct.
Because I mean, there are some facts that are fairly, even if you want to look at whatever light most favorable point, there's something here disputed about this that's there. And,
right.
and going back to the whole business of, unless you accept, and then maybe I need to ask that question, how do you read Davis? Does it require that there be continual sexual activity? And I don't want to overstate it, but at least it seems to me, if you go there, you're simply saying someone who has had unquestionable sexual assault against them, who then reports it, and the school has actual knowledge, the school can do nothing and be okay if nothing ever happens again. Is that correct?
Well, just a couple of things here.
Don't lock me into another scenario because you confuse me. Tell me, is that correct? And then go there. Is that correct? So if you have let me make sure because I want to make sure I understand this, because I don't want us to spend another 10 minutes on this. I'm trying to kill this point one way or the other. Either you're going there or not. So my question is, if there is an actual sexual assault, let's assume that it affects education. There's actual notice and actual knowledge. Let's assume that aspect of it. But if the student does all that and nothing ever happens again, there's never another sexual assault or nothing, they're okay. Is that good?
I think to accept your hypothetical, if there's an assault, the school board knows about it.
I know you want to be careful, but I thought I said that as clean and as simple as it could be. You don't have to repeat it. I think it's just an answer. Either it is or is not.
The school official with corrective action authority has to take appropriate steps in response, and that's going to depend on the circumstances.
So the answer is no. It's not. The answer is no. It doesn't. That won't be sufficient for them to get the report and do nothing and rely on the fact that it won't happen again.
Well,
they can't do that.
I think Judge Niemeyer was correct when he said.
No, I'm not answering Judge. I'm not going to debate Judge Niemeyer. He's a judge like I am. We're not going to debate each other. We are just deciding. I'm asking you. I'm just trying to be clear in terms of what does that mean? Does it mean that if you have a sexual assault, you got an educational component there that which it affects her, you got actual knowledge, actual notice, but nothing happens again, then it doesn't matter what the school did, they're off Title IX. Is that correct?
Yeah, I don't think that's correct. I don't think that's correct.
Doesn't sound like it is to me either.
Well, and just to be clear, the school board, this is not a case where the school system did nothing. Hogan believed Jane when she said that she was in a situation she didn't want to be in, but she willingly participated for 15 to 20 minutes.
I understand you have a counter argument in terms of what actually happened to defend it, but I just want to make sure as a matter of law, it's not driven those set of facts.
Thank you. And I think the other thing that's really critical about the posture of this case is it is a motion for a new trial on a jury verdict of a finding of no actual knowledge. And Your Honor, Judge Wynn, as you wrote in the Minter case, that is a very difficult standard. And in a case like this, where the plaintiff didn't move for judgment as a matter of law at the close of the evidence, the test is there any evidence to support the jury's verdict? And in this case, there is ample evidence to support the jury's verdict. And I wanted to focus on that. Number one, Assistant Principal Hogan testified that she didn't understand Jane to be accusing Jack of committing a sexual assault, but that she instead described a consensual sexual activity. That's at pages 1223, 1261, 1281, and 1286. Hogan testified that after interviewing
but that
witnesses,
goes back to my question of where is the consensual sexual activity in the handwritten note that Doe provided.
And Judge Thacker, the handwritten note would have been ample to get past a motion to dismiss or a motion for summary judgment, but we're here on a new trial motion. And the question is there any evidence to support it? So it's not, can you point to something that supports Jane's case? It's, is there anything that supports a no actual knowledge finding? And that, moreover, is consistent with the jury instructions, which told the jury that they could find the one witness's testimony credible. They could accept part of a witness's testimony and not another part. So the question
here's the problem I think we run into, and I hate to show my age. You know, things haven't always been looked upon in this way. Let me just say that. But given the state of the law and what I would call evolution and advancement of the law, it's not Mrs. Hogan's subjective intent, a subjective understanding. It's really, she's got a student who's coming into her and laying out this sexual complaint. She didn't come in to discuss how her social life and how nice it's been to be with this young man. She came in to make a complaint, and she said some very pointed things to her. Let me finish that. So when you start treading in the language the way you going, and I heard you say a couple of things today, and I could have some concern. I mean, I'm not sure that's good to say, to impute that this young lady who comes in makes this complaint under a circumstance that looks like it's intimidating, looks like it's hostile. She says she's shocked and all of these things. Ms. Hogan doesn't get she doesn't get to go there and say, well, I kind of know how life is and this is the way I don't see a whole lot here. She has to import an objective understanding to this situation. Does she not?
Your Honor is mistaken. Ms. Jane did not come in to make a complaint. She didn't report it to the authorities at all. It was Hogan who called her down because she was investigating what she understood to be a consensual sexual activity. To your earlier question,
tell me how that came to Hogan then. Why would she investigate a consensual? Because she didn't like it, the consensual nature of it. Is that that's your point, right?
So there were several phases of the incident. There was a band trip. Jane told lots of her friends about what had happened, and that filtered back to Michelle Taylor, an assistant principal on the trip. Michelle Taylor understood it to be a consensual sexual
Do you know what Jane told those folks out there? Did she tell them it was all a consensual activity?
Her testimony at trial was very different from what Hogan said she told her at the time. And that's what I was trying to make the point, that this is an appeal of a new trial motion on a full record. And your mentor stands for the proposition that if there's any evidence to support it, you have to affirm. And I was trying to get back to the evidence that supports it. I talked about the fact that Hogan testified that
what did the victim say in the first interview? I thought what she said in the first interview was different from what she wrote later.
It was. But what Hogan testified Jane told her was that she was in a situation that she didn't know what to do, and so she went along with it. And Jane was believed by Hogan. Hogan didn't think that Jane needed discipline. She needed counseling. That if you don't want to go along with something, don't go along with it. But there was certainly no outward expression that she wasn't consenting to it. And her testimony was fully consistent with a report not of a sexual assault, but of a consensual sexual event. So let me get back to the other pieces of evidence that by themselves support the jury's verdict. We talked about.
But before you do, I want to make sure we understand what Hogan did and how Hogan got this information. Young lady, Jane testifies or talks to Hogan, and then she makes a written statement. Her mother talks to Hogan and says, "My daughter was sexually assaulted." That's not factual. I want to make sure. Am I okay?
Your timing.
I mean, just those bare bones. But I mean, the timing or whatever. But nonetheless, there's a written statement.
It's important. I mean, the difference is important, Your Honor, because by the time the mother came in and spoke to Hogan, Hogan had already interviewed Jane. What the mother said was, she tried to block him, and therefore it was a sexual assault. That is not there were no new facts communicated by that. Hogan had already talked to Jane. To your earlier question, Judge Wynn, is it a subjective standard? It is a subjective standard, and that's
from whose perspective?
From the school.
From Hogan's
perspective, yes. And that's because we're not dealing here with a general civil rights statute. We're dealing with an applied right of action under Title IX, which is a spending clause statute.
So your statement is that she can receive a statement of sexual assault, or sexual harassment, and render to it her subjective understanding of it, and that is sufficient.
So can I just unpack that a little bit?
You just said it. I want to make sure. I just corrected it. I want to make sure that's what you said. So don't confuse me. Don't confuse me.
It is subjective. I would direct the court's attention to Farmer versus Brennan that we cited in our papers. That was an Eighth Amendment deliberate indifference case, and the Supreme Court looked at exactly the same issue there, which was does the knowledge have to be subjective? And the Supreme Court said yes, it does, and it dealt with the question.
Mr. Raphael, what about our Jennings case where we held that an allegation can satisfy the actual knowledge prong, even if the administrator believes the allegation does not subjectively amount to an assault, something like that?
Okay,
paraphrasing.
So Jennings was summary judgment. It wasn't after a full trial, and the court held in Jennings that the report to the Title IX coordinator and the general counsel about all of the terrible things that the coach was doing was sufficient to create actual knowledge, and that certainly gets past a summary judgment standard. Here, you have lots of conflicting evidence, and you have a story that's told by Jane and some of her friends that is very different from the story that's told by the administrators.
And who knows who was there?
Jane and Jack were there, but Judge Thacker, Ms. Hogan said, I believed Jane. I believed what Jane told me. I just didn't think what she told me was an allegation of an assault. And so I've cited some of the earlier pages, but her testimony corroborated.
Then I go back to the note. I don't where in this note is there not an allegation of assault?
Your Honor, you can't take one piece of evidence and say,
even when you said that, when she talked to Jane, she said, well, she blocked him once and then she felt pressured, so she went along with it. I don't see how being pressured and going along with it, or not knowing what to do and going along with it, indicates consent.
Yeah, she didn't say she felt pressured.
Right, I'm sorry, and I changed that.
Okay,
she didn't know what to do because she was shocked and scared.
And Hogan examined her, discussed this at length with her twice. And so, but you can't look at one piece of evidence and say, does this suggest that there was an assault or harassment? The question is the other question. Is there any evidence that goes the other way? And there is. We talked about what Hogan testified, but Jane's father also testified that after he talked to Hogan, what Hogan described to him, having spoken to Jane, was a consensual sexual encounter. That's at 1456 of the Joint Appendix. That corroborates Hogan's statement. Principal Banbury testified that Hogan reported to him that it was a consensual sexual encounter. Banbury and Hogan had the same testimony on that point at pages 977, 1030, and 1221. Jane herself admitted that she didn't view what happened as an assault until much later. That's at page 1863. And when Baranek, the security officer, asked Jane if she wanted to pursue charges against Jack, she reacted incredulously and said no, which that's at page 1281, which Hogan interpreted as acknowledging.
Well, she's already been ostracized in the band room and put in some corner. Why would she now want to press assault charges and make it worse?
Yeah, no, the evidence was that Jack was ostracized, not Jane. Her parents asked her to be allowed out of the band room, which happened only 3 times before Dr. Van Valkenburg rearranged it at her parents' request.
I'm sorry, Mr. Raphael. You gave us a JA site a minute ago about something that supported Hogan. Maybe
I had several. So the JA site.
It was 18 something.
When Jane admitted that she did not view what happened as she didn't view what happened as an assault until much later. That's in 1863 to 1864 of the Joint Appendix. And then Jane admitted that her definition of consent required an affirmative statement of yes, which the jury could have reasonably understood to mean that to corroborate Hogan's understanding that what happened was consensual. But I think the flaw in Judge Thacker, respectfully, in your question to me about what about this note is that's treating this like a summary judgment case or a motion to dismiss case. There was certainly evidence that the jury could have viewed to go the other way, but that's not the question before you. The question before you is there any evidence to support a no actual knowledge finding? And there is. And on that, you need to take the evidence in the light most favorable to the school board, which is the prevailing party. And for those reasons, the court should affirm.
All right, thank you, Mr. Raphael. Ms. Brodsky, you have a little rebuttal? hear me, Ms. Brodsky? Ms.
I think she's
Brodsky,
Might be-
frozen.
can you hear me?
She's frozen.
Wow,
Can you hear me?
you're back.
I'm sorry, I'm having,
Can you hear me now?
I'm so
Can
sorry.
you hear me now?
Am I back now?
Say something.
Okay, great. I'm sorry about that. Terrible timing.
It's breaking a little bit. Let's try it. You have some rebuttal.
Okay. Are you able to hear me with my video off any better?
We can
I think
hear
it's
you.
the same, but go ahead.
Okay, you can hear me. Okay. I realize I'm short on remaining time, so there are 2 points that I would like to make. The first is that when a school receives a report alleging that the plaintiff was sexually harassed, it has actual knowledge, period. Any other information it receives from the victim or from anyone else might be relevant to the school's credibility determination, but that's a question for deliberate
Can I
indifference.
ask you on that? When I was in school, and that's a long time ago and under a lot of different standards, but if somebody engaged in consensual sex in a school activity, like at a prom or a dance or a school bus, that would have been violating the rules of the school, even though it was totally consensual. Now, if that was what was conveyed to the school, that wouldn't be a conveyance of sexual harassment, would it?
That's correct, Your Honor. It would not be sexual harassment. And I think this goes to an important point, which is Title IX protects the educations of children. And when young people are brave enough to tell an adult that they've been sexually abused, they often don't use magic words. They don't use legal terminology. The JA site that was discussed was Jane's college admissions essay, where she said that it took her some time to understand that what had happened to her should be labeled sexual assault because she was 16 years old. And if the cases are quite clear that if a child or a parent tells the school what has happened and that constitutes sexual harassment, then there is actual knowledge. At that point, the student has done her job and it's time for the adults to do theirs.
Is the knowledge based upon a subjective determination or an objective determination?
It's objective, Your Honor, and I think that one helpful case on this point is SB, where this court considered a disability harassment case that directly borrowed from Gebser and Davis, and in determining whether there was knowledge, they looked to the contents of the report. And I will say that there actually isn't evidence that Hogan didn't have subjective knowledge. She said that by the second half of Jane's report, she understood that if Jane were to press charges, she would press charges for, quote, sexual harassment. But it cannot be that a school administrator's failure to understand what constitutes sexual harassment is an absolute bar to liability. That's why this court and others have treated a failure to categorize reports of sexual harassment. This court and others have viewed that as evidence of a deficient response. And there may be hard actual knowledge cases, but this isn't one. This family did all they could to put the school on notice. And so this court should remand for a new trial so a jury can reach for the first time the question of whether the school did enough. Thank you, Your Honors.
Thank you. All right, appreciate your arguments. Our practice is to come down and greet you, and it would be very nice to greet you in our tradition. As you know, we're the only court in the country that does that. That's left over from one of Judge Parker's very constructive inventions, and we've carried it on ever since and enjoy it. But we do greet you with the traditional courtesy and in the tradition of a handshake. And thank you for your arguments.
Thank you.
Thank you.
Okay, we'll stand adjourned.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Okay, Judge Niemeyer, I'm